If you're involved in a medical malpractice lawsuit, I'm sorry to hear it. One of the things my clients are most concerned about is what are the demands on their time as the process of litigation proceeds. My name is Jim Edwards and I'm a medical malpractice defense attorney in Stafford, Texas, a suburb of Houston. The litigation process can be divided into 3 stages, and they're not distinct steps, but they overlap. The first one is discovery. The second one is depositions, and the third one is disposition, the 3 Ds. Now, discovery is the beginning of the process, and it can go on for several months. It's a fishing expedition. It's the exchange of paper between the lawyers. The other side, the plaintiff, the folks bringing the lawsuit against you, will send documents to your lawyer. They won't send them directly to you. They're not allowed to communicate directly to you once they find out that you're represented by an attorney. After they find that out, then everything relating to the lawsuit will come to you through your insurance company or through your attorney. So, the discovery phase. It's an exchange of paper. They will send questions to your attorney in writing that your attorney will assist you in drafting responses to and send them to the other side. They can send a document called a request for production of documents. The interrogatories, the written questions, ask for written answers. A request for production asks you to produce paper. So if you have an office chart on the patient, you'll be required to provide that to your attorney, and he or she will provide it to the other side. The exchange of paper can go on, and it can continue during the process of the litigation, even in the second and third phases of the litigation, but most of it goes on at the beginning. So both sides can kind of get an initial picture of the terrain they're working in. An initial picture of the battlefield. Now, what are the demands on your time in the discovery phase? Well, the demands on your time at that phase are going to be to assist your attorney in responding to the other side's discovery. Now, your attorney will send you copies of the responses that the plaintiff sends to him or her to your discovery, but your attorney will need your help in putting together the responses that you have to send to the other side. Usually that can be done at a time, I started to say convenient to you, but that's not true. But at least the inconvenience can be minimized. Oftentimes we have to do those after hours or on weekends because doctors are busy. We're sympathetic to that, and all we do is defend doctors and hospitals and other healthcare providers. Most of the time you'll have about a month to get the responses back together. Frankly, we tell our clients we want draft responses back in about 10 days because sometimes y'all are so busy, we're lucky to get them back in time to get them filed with the court by the end of the month. But in any case, that's something that you may be uncomfortable doing, especially if you haven't been included in a lawsuit before. So when that happens, call up your lawyer and set up a telephone appointment or something, via Zoom or Skype or one of the other platforms so that you can talk to the lawyer or meet with them in person and go through those questions. You're not required to create a document if the request for production of documents asks for a list of something and no such list presently exists. You're not required to go create a list. You're not required to go get other people's records. Let's say you only saw the patient in the hospital and you don't have a chart of your own at your office or in your clinic. Maybe you don't even have an office or clinical practice. In those cases, you're not required to go get the hospital records and provide them to the plaintiff. What you're required to produce is the information that you have, that you already have, and that already exists. So the discovery phase is not going to include significant demands on your time, and they can usually be very, very flexible. Now, after the discovery phase, the next phase is depositions. Now, a deposition is the taking of formal sworn testimony outside of the courtroom, outside of the presence of a judge and jury. The law allows the parties to get together with a court reporter, put the witness under oath, and ask whatever questions they want to ask that relate to the lawsuit. That testimony is taken down by the court reporter, and she or he produces a booklet with every question and every answer in it. That's the transcript of the deposition. The benefit of that is that it doesn't waste courtroom, judge, and jury time, and both sides get a very clear picture of what's going on the other side and what the other side's story is going to be, which frankly leads to the resolution, the settlement of a lot of cases. The demands on your time in the deposition phase are 1, to prepare for your deposition, and 2, to give your deposition. Now, preparation for your deposition is usually going to involve 1 or 2, sometimes, rarely, more meetings. Those are usually going to last an hour or 2 each, and your lawyer will go through the process of a deposition with you, will address the critical issues in the case, anything that you're concerned about, and will advise you about the details about how to handle difficult questions and how to handle different types of questions. Now, I won't go into those details here. They're covered in great detail in my book, and they'll be covered in a later video on this channel. The deposition phase after the preparation for it involves the actual deposition. That'll be either in person or by video. Your lawyer will be present. A lawyer for each of the other parties in the case will be present as well. So if there's multiple defendants, if you got sued and 3 other doctors and 2 hospitals and a nurse practitioner all got sued, there'll be a lawyer for every one of those folks at the deposition. And those lawyers will be allowed to ask you any questions that they want to ask. But the bulk of the questions are going to be asked by the plaintiff's attorney. And those questions that are asked by the plaintiff's attorney are not like the oral boards. You're not going to be asked about extrapyramidal reactions to the phenothiazines. You're going to be asked about what you remember, what you decided, what you were thinking when you were providing care and treatment to the patient in question. Depositions can last a long time. They normally don't last an excessive amount of time. Some venues, some states have put limits on the length of depositions. Usually you hear things like 6 hours or 8 hours of talk time. To get 6 hours of talk time with bathroom breaks and lunch breaks usually takes all day. But it's very rare to have a deposition go on that long. Most depositions will last 2 or 3 hours unless the case is exceedingly complex. So you'll need to set aside a day, but it's probably not going to take up your whole day. So after the discovery phase and the deposition phase comes the disposition phase. How do you get rid of this thing? How do you make it go away? Well, the vast majority of these cases never go to trial. They are either settled or they're dropped. So statistically, the probability is that you will not see a jury in your case. That's not always a good thing. I've had situations where doctors were groomed for settlement from the very first meeting with the lawyer who was retained by their insurance carrier, and I discussed that in another video on this channel and in my book. But you may decide that you want to defend yourself. And if that's the case, you'll probably get the opportunity to do so. Because in the disposition phase, the first thing that happens nowadays is almost all of these cases are sent to a one-day settlement conference called a mediation. Now, mediation is not an arbitration. In an arbitration, the arbitrator is judge and jury, and he or she says you win, you lose. A mediation is a settlement conference. The mediator is usually an insurance professional or a lawyer who has taken some additional training in how to facilitate settlements. There's no preparation on your part for a mediation. You're not asked any questions. There's no court reporter there. There's no research or anything, any homework that you have to do before a mediation, but you have to be present. The courts have found if they get all of the parties and all of their lawyers and any insurance representatives who are involved in the case, if they get them all together one day, one place with a mediator who's trying to facilitate settlement, that it greatly increases the chances that a case will settle and the court's docket will be cleared of that lawsuit. At the mediation, in most cases, the doctor's insurance policy provides that the doctor has a right to consent or to refuse to consent to settlement. Now, there are implications to consenting or refusing to consent to settlement. There's not time to cover them in this video. They are covered in a future video and covered in my book. But you will have to make a decision about whether or not you want to consent to settle the case. Even if you do consent to settle the case, it does not mandate, it does not require that your insurance company pay money and settle the case. They can say, we understand, you consented to settle the case. You're in the business and you're an expert at taking care of sick people. We're in the business of accepting and distributing risk. We've looked at the case. We think you practiced good medicine. We're not going to settle. We're going to go to trial. And you're still obligated to enthusiastically participate in your defense and to be prepared to defend yourself even if the insurance company decides to go to trial after you have consented to settle. So mediation happens. If the case settles, great. Everybody's somewhat happy and somewhat dissatisfied and goes home. That's the end of it. If the case does not settle, then you have to hope that it's either going to be dropped, which is statistically exceedingly unlikely, for reasons discussed in other videos and in the book. It's not in people's interest usually to simply drop a case, especially after they have invested time and money into pursuing it. But a few get dropped, and we always work to try to see that if some defendants settle the case, we try to convince the plaintiff's attorney to drop the case against our client. If they don't, then you go to trial. We always want a jury trial. We don't want a one-person judge and jury, so we don't try our cases to judges, and I think the vast majority of medical malpractice defense attorneys throughout the country want jury trials. Juries like doctors. We all like doctor shows on TV and doctor movies, and so most of the time, the vast majority of the time, if you have a case that is not disposed of either by settlement or being dropped, then it'll go to a jury trial. Now, the demands on your time in the disposition phase are 1 day to participate in the mediation, and then preparation for and attendance at trial. Preparation for trial will usually involve 1 or 2, sometimes more meetings of an hour or 2 each to prepare you for your testimony at trial. But the nice thing is that during the deposition phase, you've had a dress rehearsal for your participation, a dress rehearsal for the questions you're going to be asked at trial. In addition to preparing for the trial, you'll be needed to be in attendance at the trial. I want my clients present whenever the jury is present. I don't want the jurors to be looking at a situation where they say, well, we've got to be here. Why isn't he or she here? I don't want them to think, well, they don't care about it, and they start thinking, well, insurance is going to take care of it. We don't care about it either. So I ask my clients to be present whenever the jury is present. Now, sometimes that's not possible. I've defended doctors in small towns who had to be away from the courthouse. I've defended doctors in big cities who had to be away from the courthouse, and usually we can work around that. But optimally, you'll be present whenever the jury is present. Most of the time, the courts will run on a business day basis. That is, they'll start with the jury at 8 or 8:30 or 9 o'clock in the morning, and they'll end at 4 or 4:30 or 5 in the afternoon. So you'd normally be free in the evenings. We usually keep our clients there for at least a little while to kind of go over what happened that day and to prepare for tomorrow. Once the trial is started, it usually goes continuously, day to day. It's rare, it sometimes happens, but it's rare that they will be interrupted, so you'll need to block out that time. But don't block it out until your attorney tells you to do so. Many times cases are set for trial and don't go to trial at the trial setting. The courts have to set a number of cases for trial, otherwise they're sitting with empty courtrooms when cases settle or are dropped. So talk to your attorney before you block out your time. So the demands on your time in the disposition phase are preparing for trial, attending mediation, and attending the trial. So I hope this has been of some help to you. I hope you have a good picture of the litigation process that you're involved in if you're involved in a medical malpractice case. If it has been helpful, please return the favor and click like, follow, or subscribe. And best of luck in your medical malpractice case. Watch for more information in our next video. Thank you.